Indian Constitution, Article 10. Continuance of the rights of citizenship. Article 10 provides that every person who is or is deemed to be a citizen of India under any of the foregoing provisions shall continue to be a citizen of India subject, however, to the provisions of any law that may be made by Parliament. Thus, in exercise of this power, Parliament may take away the right of citizenship of any person. But the right to citizenship given under the foregoing provisions can only be taken away by an express law made by Parliament. It cannot be taken away indirectly. In Ibrahim Wazir vs. State of Bombay, 15 the Constitutional Validity of Influx Form Pakistan Control Act 1949 was involved. This act provides that no person domiciled in India or Pakistan shall enter India from Pakistan without a permit. If a person enters India without a permit, he commits an offence punishable under the Act. Section 7 of the Act authorizes the central government to direct the removal from India of any person who has committed or against whom a reasonable suspicion exists that he has committed an offence under the Act. The Supreme Court held that Section 7 was ultra vires of Parliament because to allow the forcible removal of an Indian citizen from India would be tantamount to destroying the right of citizenship conferred by Part 2 of the Constitution. The right of citizenship, the court said, could only be taken away by recourse to Article 11 of the Constitution. Thus, in absence of any law expressly made under Article 11, the right of citizenship cannot be destroyed by an act made for a different purpose. Draft Article 5C, Article 10, was debated on 10, the 11th and 12th August 1949. It was not initially part of the draft Constitution 1948. Instead, the chairman of the drafting committee proposed its insertion. It clarified that people declared as citizens under the preceding citizenship articles continued to be so subject to any law made by the Parliament. While there were no substantive discussions around this article, one member moved a motion to delete this article as he believed that it was unnecessary and redundant, and that draft Article 6, Article 11, was sufficient for these purposes. The chairman of the drafting committee reiterated that the articles on citizenship were temporary in nature. It was to be left to the future Parliament to enact a comprehensive citizenship code. The Assembly adopted this article without any amendments on 12 August 1949.